So, Miss Justice Nuala Butler has presided over the probate list in the High Court for 18 months or so. She has been now promoted to the Court of Appeal. But the Probate Bar Association held a conference there last week and she spoke at it. And she had some interesting things to say about probate and what she has seen in the High Court. For example, some people who challenge wills are prepared to have legal costs use up the entire value of a deceased's estate simply to prevent anyone else from getting it, she says. So this lady, as I say, has presided over the probate list in the High Court for the last 18 months or so. So she would have seen a lot of the disputes coming in there, rows about wills and so on. She talks about a case involving two brothers fighting over a farm with a nominal value of €60,000 and the claims including lack of capacity of the testator, forgery and evidence from handwriting experts. It seemed that one brother who had done all right in life was going to use up the value of the estate before the other brother got anything. She said many will disputes are due to family issues, including poor relations between siblings, unresolved issues concerning first and second spouses, a testator singling out one sibling or a family feeling displaced by another person getting what they regarded as their rightful inheritance. She mentioned the question then of capacity issues, and she said she was pleased to see some solicitors work together in disputed cases in an effort to reduce costs impact on the value of the estate. But that is the problem with probate rows going into the High Court. Basically, a disaffected person can bring a claim, and the likelihood is that the costs for the claim, whether it's a very strong claim or whether it's spurious or vexatious, the costs will probably be taken out of the estate itself, which is very unfortunate. Miss Justice Butler, as I say, she presided over the High Court's probate list for about 18 months. She was appointed there last week to the Court of Appeal. She was saying that probate law is quite technical but is balanced by a human element because it's all about relations between people, how they build up, how they fall apart, how families deal with the loss of people. She says the more difficult category of lost will cases arose where the will was lost in the hands of a testator, and this was even more problematic if a will was handmade because there's generally no record of it outside of claims about it by family members. In relation to cases concerning testamentary capacity, the average age of the deceased was in the late 80s or early 90s. With increased age comes increased frailty, both physical and mental. But there's an increased recognition that capacity is not a black and white issue, and that a person can have reduced capacity in some areas but still have testamentary capacity. She said the probate office is reluctant to issue a grant of probate where a death certificate indicates dementia or similar condition within 6 years of the date of a will, unless there's an affidavit concerning capacity from a solicitor or a doctor. She says that there's a particular reluctance among doctors to provide affidavits unless they've personally assessed capacity at the time the will was made. This creates difficulties when a court is trying to build a picture of a testator for the purposes of deciding whether they had capacity or not. The conference then, the Probate Bar Association's conference, dealt also with the new law coming in relation to assisted decision making and so forth, but I'm not going to talk about that now. That's a subject matter for a different video. But it's interesting that Miss Justice Nuala Butler, who would have seen a lot of action, a lot of disputes, sad disputes between families and disappointed siblings and disappointed sons and daughters and so on, all sorts of disputes over the 18 months that she has presided over the probate list. And as I said, the headline is basically that she has seen situations where some people are perfectly happy to dispute a will even though they know that the legal costs are going to drain the estate entirely. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.